This is the current federal tax developments for the week of June the 2nd, 2025. Current federal tax developments are brought to you by your state society of CPAs. At Zollers, recording here in Phoenix. We're going to go over what's gone on in this short week we had following the Memorial Day weekend. And in fact, pretty much what we're going to have here is a few reruns, shall we say, of some prior cases, an interesting week involving some other issues. Basically, we're going to go back and finally finish the results in the Soroban case. We'll talk about that case. We first discussed this case in November of 2023 when the first Soroban decision came down. We're now going to apply the second one, which looks at whether or not the partners in Soroban were truly going to qualify as limited partners under the functional test. Second, something got a lot of coverage across the press this week. It does deal with taxes, but we're going to talk about the presidential tariffs that were subject to challenge this week. Basically, 2 losses in trial courts, but we've had the basically the nationwide or the overall order stayed, and the federal circuit has scheduled time essentially to hear arguments over whether or not the order of the trial court should be essentially stayed permanently or whether it should be allowed to go into effect. All of that is probably all just preliminary to when the U.S. Supreme Court ends up having to get involved. We're going to revisit the Welch case from Massachusetts. We talked about that earlier this year. Welch was a case where a founder of a business moved outside of Massachusetts shortly before selling his stock in the business and discovered the state of Massachusetts wanted to treat that as Massachusetts source income. Well, this week, Mr. Welch filed a petition to have his case heard by the Supreme Court in Massachusetts. So we'll talk a bit about what he's pushing on, what his arguments are, and a little bit of review of that case. And finally, we're going to talk about a case that involved penalties involving failing to file your 3520 when you receive a foreign gift. But the more interesting part of the case, in many ways, is the fact that it appears that this might be a case where the TurboTax defense, which is kind of infamous among tax pros, may have actually worked. So, or at least it's not been told yet that it doesn't work. So we'll talk a little bit about that. But let's go on. Let's talk about the Soroban case, Soroban number 2. And I have that as number 2 because we had a reported tax court decision in November of 2023, where the court held that merely being a state law limited partner did not automatically mean that all the income flowing to you from the partnership that wasn't paid as guaranteed payment would be counted as would be basically exempt from self-employment income under 1402A13. Well, as you may remember at the time, that was a motion for summary judgment entered by Soroban, and essentially stating, well, the fact that they're state law limited partners, which the IRS never disputed, that should be dispositive. That's all we need to know about the case. The IRS, of course, was arguing that no, that's not how this worked. You may remember in November of 23, the court ruled that IRS is right. That's not how this works in the view of the tax court. And we spent a lot of time on the words as such when we were dealing with that. Now we're going to see this is when the tax court decides, well, okay, assuming that that is the test for Soroban's partners, do they meet the test of being able to, using the functional test, are they truly limited partners under the federal law test the tax court has put forward? Or, do they really end up failing to meet the qualifications and all the income flowing to them will be self-employment income? Now, the case citation is Soroban Capital Partners LP versus Commissioner, Tax Court Memorandum Decision 2025-52. And as I just told you, there is a reported tax court decision from 2023 that will effectively have the same name. So just be aware of that. This one came down May the 28th. Now, the key issue in the case was determining whether a partner's distributor's share of income is subject to self-employment tax under Section 1402A13. Having in the back of your mind, remember, the court had already decided that the mere fact they were state law limited partners did not end the discussion. Rather, you had to go through what was referred to as going to be a functional analysis of what they did inside the partnership, which was drawn from the old case of Rankmeyer, Campbell, and Weaver, which was one of a series of cases that have dealt with all the other variants we have out there of limited liability somethings, but didn't deal directly with limited partnerships themselves. So this is the first case that really looked at limited partnerships themselves. And do we use the same rules as were used in the cases involving the LLCs? Now, bottom line, the court decides you must look beyond state law labels when determining limited partner status for self-employment purposes, and it provides application of the functional analysis test. This was a test that we knew were going to have to be used in the Soroban 1 case, but it wasn't well described how it would work. And more recently, we've had the Denham decision that did go into a lot more detail about how to apply the case. This one will add some more to that. Now, the entity structure here is we have Soroban Capital Partners LP. This was a Delaware limited partnership. It was wholly owned by three individuals, Mrs. Mandelblatt, Capitia, and Friedman, through a general partner LLC and through direct and indirect limited partner interests. Now, confusingly enough, the general partner LLC is also called Soroban. Yeah, it was all kinds of different structures, but it's also referred to as Soroban. So you got to be careful. When we use the word Soroban in this discussion, I'm talking about the limited partnership. We're going to refer to the general partner LLC as a general partner in this case. Now, Soroban generated significant ordinary income, right? And these limited partners, remember, it's a limited partnership. These state law limited partners reported only their guaranteed payments as self-employment income. They excluded their share of other partnership income. This goes under Section 1402A13. 1402A13 is an exception to the general rule that income flowing out to a partner from a partnership will be considered self-employment income. That exception says that we will not consider self-employment income to include amounts received on, as allocation to a limited partner as such, which is the term that's in the code, except for guaranteed payments paid to that partner for services actually performed. Now, the IRS position was that they were not limited partners acting as such, theory being that that was the test, acting the way limited partners did back in 1977 when this statute was passed, for the purposes of 1402A13, and a functional inquiry was necessary to determine if they were going to be subject to self-employment tax. Had they done enough to trigger having to pay the tax? Now, the basic framework of the law we have here. Under Section 1402A, every partner includes a distributed share of partnership income in net earnings from self-employment. Now, that said, under 1402A, there are a series of exceptions. The first one, for instance, says anytime you have income from rental of real estate, even if it's a trade or business, doesn't matter. That's excluded from self-employment income. Now, that is not the same thing, though, as lodging. So if you're providing lodging, then that generally will be considered subject to self-employment income. One of the exceptions, the 13th one exact, lucky 13, is found at 1402A13. It excludes a distributed share of a limited partner as such, other than for guaranteed payments for services actually performed. Now, the tax court held in the first Soroban case that 1402A13 requires a functional analysis to determine if the partners were acting as such. Federal tax law, not state law, labels control. Remember, the position taken by Soroban was they were limited partners under applicable state law, Delaware in this case. And so because of that, they said, well, we should automatically get the coverage of 1402A13 because clearly Congress meant limited partners under state law. The tax court disagreed. Now, the goal of functional analysis is to determine if the partner was generally akin to a passive investor which the court said was what Congress meant when 1402A13 was first passed. And 1402A13 was, and there's a little question about this, a provision that was passed initially to prevent people who weren't going to earn the right to collect Social Security, that they could make minor investments in limited partnerships and therefore get enough income flowing to them to pay into Social Security enough to trigger being able to get the benefits. They would get their adequate number of quarters to do so. That was something that was, frowned upon, let's say, by Congress late in the 70s. They decided to clamp down on it, so we got this rule. It was not until after this that we saw the changes to, or in fact, now it was like a year or two after, as I recall, that Wyoming adopted the first LLC statute. And that was where everything gets a little confused now as to what are those things. And then we'll also have limited partnerships being modified. In 1977, limited partnerships, every state had what's called the control rule. And the control rule said that if you basically start exercising enough management activities to effectively exercise a level of control, you lost your limited partner status. In essence, you could be held liable for the debts of the partnership. A number of states, not yet a majority, I don't believe, but still a significant number of states, now have removed the control law from their limited partnership statute. Therefore, you now can have a limited partner that very actively participates in the business. Now, the burden of proof was on the taxpayers, Soroban, right? Proving that the IRS's adjustments, which drew all the flow-through income into SE income, were erroneous. Now, there's some key facts in this case. The source of the income of Soroban was entirely from investment management fees paid to Soroban. The principals had a major role in this income generation. Their time, skills, and judgment were essential. They managed the portfolios. They led the entire investment process. They oversaw risk management, and they, essentially, managed the entire investment team. All three of them participated in management. All three of them served on multiple oversight committees for brokerage, trade allocation, valuation, and management. And basically they controlled the personnel decisions, who was fired, hired, who was basically promoted. The time devoted, and this is something that was borrowed, we've seen it brought up in the other cases. The principals treated Soroban as full-time jobs. They devoted 2,325 hours annually, and this is key. They were prohibited from having other investment style work. They had to devote themselves entirely to Soroban. And make things worse, from the position, at least, of Soroban, we get to this, it's a bad fact, they explicitly advertised and promoted their principals' unique skills by name as critical to the fund's success. And there were various provisions that essentially, if one of them left, certain not good things happened, and investors were let out of certain items they had agreed to do. That's all bad, right? The court found that was bad. The court also noted that the capital contributions of these principals was utterly insignificant compared to their distributive shares. That suggests that what they were being paid for was not a return on investment. It's not like, we had to go out and spend $2 billion to build a factory, buy all this equipment, and put all that together, and after that $2 billion, we were getting $4 million a year, right? Because you could say, well, wait, on $2 billion, there should be some return on that, right? That we should have. But rather, two of them had no cash contribution. And while one of them contributed $4.3 million to the partnership, so that would seem significant in many cases, the problem was, over 2 years, that partner got over $80 million in distributions. This disproportionate level, huge amounts of, flow through income distributions with very little or relatively little, in this case, about 5% of 2 years distributions, or none, 0% of 2 years distributions, put in, made it say, well, this is not a return on capital. That's not what's going on. Now, the court rejected the proposed factors that relied on state law labels that were pushed by the partners in Soroban, right? They also said, there was the other thing they tried to do. They said, well, no. All management of the partnership goes through the general partner. Remember, they were all considered to be, they each owned a third of the general partner. And they said, well, they were only doing work in that role. And the court rejected that argument. It said, they rejected that they had merely acted under the delegated authority of the LLC. The court labeled that a legal friction, given that, the ownership's identical, everything's the same. This is just a little structure you put up over here to say, hey, look, that's where we're doing it from. We're over there. Court disallowed. Court didn't go along with that. They denied a motion that the partners had to try to reopen the record to add information from earlier and later years. The court said, okay, we're going to let the earlier years in. It said later years don't matter for this purpose. But even then, they said, even breaking that in, it doesn't show that really, the income shares were not related at all to how much capital you put in. They were trying to argue that the 2 years in question were unusual. And they said, no, not really. Even if I go back and just consider those years, income shares you were not paying out income based on invested capital. That's not how it was working. So the court concluded that these principals were limited partners in name only. They were not federal law limited partners. Their roles were inconsistent with past investors, which is what Congress considered to be what they were barring when they put this provision in the law. We're going back to those sorts of theories on ways to analyze the statute. And these are ways we've seen raised in various forms in positions you would see put forward in arguments for textualist interpretations of statutes. And there is one, what did the term mean at the time the law was enacted? When Congress voted on it, what did the term mean? Rather than what does it mean today? And we also got the weird as such rule too, right? They said they're not passive investors. They're saying limited partner as such clearly meant being passive and not involved, because that's what it was in 1977. They were completely essential in generating all the income of this partnership. They were in management, overseeing management, very hands-on, worked full times. And everybody that invested with this group, they were told these guys were essential to the group's activities, right? So that was how they ended up doing it. Now, so the holding, the principals were not limited partners in the meaning of 1402A13. The distributive shares of ordinary income constitutes net earnings from self-employment, and decision was entered for the commissioner. This is not surprising, right? I think when it came out, I posted on social media quickly that this might be the least surprising decision of the year, that Soroban lost in the second round. Pretty much thought they would. Remember, we have discussed there is a case that was argued in February before the Fifth Circuit, talking about Sirius Solutions LP, which is basically about the same matter. And while Sirius was decided after the first Soroban case, remember in Sirius, they agreed to say, look, tax court, if you're going to tell us that, we're going to have to do this functional test for us, that merely being a state law limited partner is not good enough, then we'll go ahead and concede that if that's the way the rule applies, then we'd be subject to SE tax. That tactic allowed them to shortcut. Now, there's a little risk there because it is possible that somehow we could discover if the courts do accept functional definition, that they might still come up with a test that the partners in Sirius would have passed. There's a little risk in bypassing it, but I think probably not that huge of a risk. And in essence, I really think they wanted to get before the Fifth Circuit first, right? We've had Denham file in the First Circuit. It would appear that this case should probably go to the Third. I believe it's the Third Circuit would hear this one. I believe it's a Delaware operation, although they also have things in New York, so not clear to be Second or Third Circuit. But it does mean there's a very good chance we're going to have 3 different circuits ruling on this in the near future. And, if they all come to the same conclusion, and it's not what the tax court came to the conclusion on, then that's probably going to put a lot of pressure on the tax court to reverse. And if they split, then probably that's going to force the Supreme Court to pick up the issue and go with it. So the key takeaway is from the tax court right now, state law status is not determinative for your SECA tax exception, right? We have that. Now, the actual way this matters probably at the moment is not huge. If you are in a state that still has a control requirement in your limited partnership statute, Arizona still does, so it doesn't really directly affect me. But if you're in one of the states, and as I said, it's not a small number of states that have gotten rid of the control requirement in their limited partnership statutes, then yeah, it could very well matter. It could be a big thing. Now, if you do have this issue, you need to perform a thorough functional analysis for partners, title limited partner, and you should probably review both this decision in Soroban and the Denham capital decision, because that gives you a lot of detail about applying this functional test. The factors you want to examine are the actual involvement in income generation, actual involvement in management, how much time did they devote, is the skill of these partners, really become a big thing in marketing? We're talking about how great these guys are, and they're the ones that are responsible for the magic. And we're pushing that hard, and whether income is a return on capital or compensation for services. Fundamentally, we're saying that even though you're a state law limited partner, we still are going to apply the Rankmeyer decision to whether or not you're going to be treated as a limited partner for the exclusion from self-employment income. And that means that, if in fact the tax court's position is upheld on the appeals, that suggests the bar for excluding anybody's active member's income, share from income, would be very, very high, be very difficult. Maybe not impossible, but I think you would need a significant investment in capital. With that, you might be able to argue your way around this and get it done. But otherwise, yeah, it's an interesting mess. My own take, I think the Fifth Circuit, if the Fifth Circuit were to rule for the tax court, which I don't think they're going to do, my gut reaction right now is they're probably not. But if they do, that might be the end of the discussion, because if the Fifth Circuit's not willing to overturn this, then it's going to be tougher to find a circuit to do it. So either you go to Supreme Court and hope they buck the circuits entirely, or you just realize you're going to lose on this. If the Fifth Circuit rules in favor of the taxpayer, that would create uncertainty and would change everything in the Fifth Circuit if you're subject to that. But then we would probably want to start watching the next couple of other decisions. But again, from the standpoint of the taxpayers, they're still in the game. And if they get if the next 2 circuits, if Denham and Soroban, let's say those 2 are the next 2 to come up from the circuits, if both of those courts were to agree that, the tax court can't do this, then it would put pressure on, right? The tax court, if they've lost 3 separate appeals, 3 separate different districts, 3 separate circuits with no wins, that's traditionally been the point at which they give up. And if we do get a difference in the circuits, then it would give you, the chance to say, hey, let's go to the Supreme Court and let's try our luck there. You'd have a better chance of getting them to take up the case. Okay, let's talk about tariffs. And these are presidential tariffs under the IEEPA. That is the act it was imposed under. And this will be under the decision of the U.S. Court of International Trade, its decision, the Federal Circuit stay, and I will briefly mention a U.S. District Court for the District of Columbia case that was actually, it issued its decision in the midst of everything else. So we'll talk a bit about that. Okay, so this is a case where the Court of International Trade struck down the presidential tariffs under this particular rule, this International Emergency Economic Powers Act, IEEPA. And we're going to also find that the Federal Circuit has temporarily stayed the order that would have forced the removal of these tariffs. Basically over the next few days, it would have been forced to have basically backed them down. Now we are going to await the Federal Circuit's ruling. At least at the moment, that's what we're going to do. We'll see how everything else runs. Now, the U.S. Court of International Trade case and the one that went to also the Federal Circuit, these are the consolidated cases of VOS Selections, Inc., which was a business that was in the business of importing various kinds of high, expensive alcohol, let's say, that was brought in and imported from around the world. This is the best alcohol of each type from, everywhere. And was also various states. And each one of these had others with them. But you had the state of Oregon is listed as a lead plaintiff versus the United States. Right? And the Federal Circuit effectively has the same group in front of them. You're going to see that there. Now, the U.S. District Court for District of Columbia, I'll just mention that case, Learning Resources, Inc. et al. Versus Donald Trump et al. And again, this was a district court action, 25-1248 from the U.S. District Court for the District of Columbia, issued on May the 29th. Now, the key issue before all of these courts is a question of the president's authority to impose tariffs under the International Emergency Economic Powers Act, which is found in Title 50 U.S. Code, sections 1701 to 1710. Now, both of the trial courts, the U.S. Court of International Trade and the D.C. District Court, found that the tariffs were unlawful, violating the Constitution. In essence, the president, Congress can't just cede over all control to the president to set taxes where he wishes. There have to be some of those, those decisions have to primarily be in Congress or be very carefully directed. And there was also a question of whether Congress had even given this sort of broad authority or intended to. And in the Federal Circuit order said basically, we are going to temporarily stay the U.S. Court of International Trade's judgment and the injunction temporarily until we're able to deal with this case. So it kind of put everything on hold. That, in many ways, I think makes sense because it was going to take a bit of time for these tariffs to be wound down, everything to be done to get them off of all the goods. It wasn't going to be able to happen instantly. So the Federal Circuit, figuring that they're going to hear these cases quickly and presumably move quickly to a decision, it didn't make sense for everything to be winding down, because if they said, nope, you know what? The Court of International Trade is wrong, then you have to fire them all back up again. So the idea is they've been there for a while. We're going to let them sit for a little while longer, and then we'll issue our decision. As I said, most likely, whatever they decide, do not be surprised if we see a move to the U.S. Supreme Court, trying to get Supreme Court to pick this up. Now, let's talk about these challenged emergency tariffs. The basis for the tariff: they were purportedly imposed under the IEEPA, and it grants powers to deal with unusual and extraordinary threats to national security, foreign policy, or the economy after declaring a national emergency. Now, this offers some broad powers, broad issues. Doesn't really specifically talk about tariffs per se in detail, but that was the method used. Now, the tariffs that they challenged include trafficking tariffs. These were imposed on products from Canada, Mexico, and China, citing emergencies related to international cartels, the southern border of the U.S., and the failure to intercept traffickers and precursors. Basically, this is the fentanyl theory, And there was the worldwide and retaliatory tariffs, and these were tariffs on all imports with higher rates for specific countries. And the cited emergency included lack of reciprocity, disparate tariff rates, non-tariff barriers to U.S. products entering the country, foreign policies that suppress wages inside the country, and the fact there were large U.S. trade deficits. That was cited as what was the emergencies, and the tariffs were meant to solve, and basically in response to those. Now, the key thing is that the U.S. Constitution does specifically provide that the power to lay and collect taxes, duties, imports, and excises, and regulate commerce with foreign nations rests exclusively with the Congress. The Constitution lays out these are the powers of the presidency. This is the power of Congress, right? Congress can delegate that authority. They often do, to some form of the executive branch, like when they say the IRS shall write regulations to do X, but they must provide what the court called an intelligible principle when doing so. Right? They can't just say, hey, you know what? We don't want to deal with taxes anymore. President, you take care of it. Not allowed to do that, right? They need to have intelligible and limiting factors. Now, the court applied the non-delegation doctrine, which says, you don't just presume a delegation. You're going to have to find, it's got to be narrow, specifically tailored, etc., and clear. They also imposed a doctrine that the Supreme Court's used a few times in recent years, called the major question doctrine. And in essence, Congress can't bail off or hand off decisions on major questions to the executive branch, that all major questions must be decided by the U.S. Congress. So in analyzing the case, the Court of International Trade used these two as the way they analyzed whether or not what the president had done, was a valid exercise of power, or whether it was invalid because Congress didn't provide an intelligible principle of how it could be used, or it was invalid because it violated the major questions doctrine. This is too big an issue to allow the president to just take over congressional authority on. That Congress needs to vote for this. Right? That's it. Now remember, the challenge here is such that basically this challenge essentially doesn't raise any issue where if Congress voted these things in, there wouldn't be a problem, right? They could be done. Now, the language in the IEEPA that the government rested its case upon was the authority under that power to regulate importation found in Title 60 U.S. Code, Section 1702A1B. And they argued that the precedent of a case called Yoshida 2, that justified using it for this sort of, tariffs. But the court said that was a limited import duty surcharge under similar language found in a separate statute, the TWEA. But that case even itself warned against unlimited power that would subvert congressional intent to maintain control over its constitutional powers to levy tariffs. That this goes back to the early 70s and a tariff imposed by Richard Nixon. The court had upheld the tariff, but noting that it was of a very limited nature and essentially was imposed under a different set of rules, not this one. The court found that the worldwide retaliatory tariff lacked any identifiable limits in duration or scope, unlike those that then President Nixon had imposed that were challenged in Yoshida. Right? They said an unlimited delegation, if Congress actually did that, would be unconstitutional. It would be void, as done. But they also said the legislative intent of the IEEPA was enacted to limit broad executive authority under the TWA, particularly in peacetime. Routine, non-emergency regulation was intended for other legislation. They're saying it's being misused. You can't declare something an emergency. It's not, it's not carte blanche on what's an emergency. That was meant to be very, very involved and generally was, had been used previously only in essentially times of war, right? And Section 122 of the Trade Act of 1974 identified such other legislation, right? It grants president limited authority, 15% tariff for 150 days maximum to impose surcharges for fundamental international payment problems, including trade deficits. So the president, under the authority of that act, could impose a tariff unilaterally, but it would only be 15% and could only go for 150 days before there is a much longer and involved process that must be completed to be able to continue to impose the tariffs. Right? It said, these world and retaliatory tariffs that you're showing me right now, that was one category, that are being imposed because of the deficits, right? They didn't comply with those limitations of a very specific act that said they could max be 15% for 150 days. These claim to be of unlimited duration and in many cases well above 15%. So the IEEPA's general authority does not permit such tariffs in this context. Right. Basically, general rule of law interpretation, a more specific act will override a broader act or a broader term. The idea being this more specific case, the court found was right on point for what the justification was the administration offered for these tariffs. Therefore, you have to follow that rule. You can't impose it under IEEPA. You have to use the more limited rule, which will be more of a pain to use. Let's be honest. Now, the IEEPA condition it authorizes may only be exercised to deal with an unusual and extraordinary threat and may not be exercised for any other purpose. So you have to show that this tariff would deal with an unusual and extraordinary threat. The court then goes into deal with. The court interpreted the term deal with to require a link between the action and the problem. Imposing a tariff is directly involved with the problem. The court found that the link between imposing a tariff and failure to intercept traffickers and drugs by those countries was simply there was no direct link. It was at best, they were arguing, essentially the government argued that, well, this gave the government leverage, to create pressure or leverage. The court found that unpersuasive. They said that would render the statutory limitation meaningless. Remember, it does say to and not to be exercised for any other purpose. So it suggests a limited reading is what the court was saying. The conclusion, the trafficking tariffs were aimed to create leverage rather than directly addressing threats, did not meet the deal with condition of 1701. And so even though they weren't the types of tariffs that were limited by the earlier act, the 74 Act, they nevertheless, you failed to meet the condition of IEEPA. You've got to show direct connections. It wasn't that you were taxing something and that taxing would cause the problem to go away. Probably not going to do much good to tax, illegal drug traffic coming to the U.S. That's like, well, that's probably not, imposing a tariff on the illegal traffickers. Yeah, probably they're not going to stop by in customs and pay it. We'll just say that. And that wasn't how it was structured anyway. The court found that this was a clear misconstruction of the statute. Therefore, invalid. The overall findings was that the IEEPA, which is what the administration relied upon, did not authorize any of the challenged tariffs. They exceeded the authority under 1702 regarding balance of payments deficits, an area that would be covered by the specific section 122. Again, that one they couldn't impose tariffs on. And by the way, a response here, if the administration loses, is going to be that they will just probably go under that provision. So, it doesn't mean that there will be no tariffs. It does mean they'll be capped at 15%, unless the administration goes through a rather complicated set of rules that require specific investigations, findings, etc., which probably would be difficult to do against as many countries as they basically put the net out for with the tariffs they have now. So most likely you would probably have to be a bit more targeted in the countries you decide to go after. The relief, they granted the plaintiff's motion for summary judgment. The challenged tariff orders were vacated and their operation was permanently enjoined by the court. Now, permanent lasts about 24 hours, but we'll get to that. The court decided as well that the order would not just cover the plaintiffs in this case, not just the liquor importer, right? And the other companies that showed up and not just, activities going in part in the states that participate. They said the Constitution requires that tariffs be uniform across the United States. As such, if they're illegal, they have to be illegal for everybody. So the court said we have no option but to strike it down entirely, not just for the plaintiffs in this case. And they also said the plaintiffs, the business in the states, had to standing based on economic injuries. Specifically, that liquor importer pointed out that due to regulations in the various states they operated in, they had to set their prices, 30 days in advance. They had to have their prices to the liquor board, and they couldn't change them for like 30 to 60 days. And obviously, as rapidly as these tariffs have been coming and going, that's, it's not hanging around for 30, 40 to 50, 60 days to get a, standard setup class. So that was their harm, that it was impossible to operate their business under the current structure using this law. And that would be their argument. We want a law where Congress imposes a tariff, and if we want to change it, we have to go back to Congress again because we need some predictability. That was kind of their argument. The states also could show not just for direct imports. Direct imports, they said, obvious where the harm comes, but they also said there was knock-on impacts of those tariffs, because the imported goods get used in other goods, and eventually it has a negative impact on the state. So they found they had standings as well. And also they found the U.S. Court of International Trade exclusive jurisdiction. I have a feeling that there's a district court in the District of Columbia that apparently disagreed with that view because they issued their own ruling. We talked about that already, but we'll go with that. That's what is there. Now, the administration immediately filed an appeal with the Federal Circuit. As you probably know, if you've been around taxes, right, the Federal Circuit hears a lot of these nationwide court appeals. So in addition to hearing the appeals of, where there's one major location, we're used to hearing them when we talk about the U.S. Court of Federal Claims is where we usually hear about them in tax matters, where I usually talk about them. But they also have jurisdiction over this court. They have a number of others too, but this one's in play as well. Now, the citation is VOS Selections, Inc. versus Trump for the Court of Appeals for the Federal Circuit, issued May the 29th. It was a non-presidential order. The government had asked the Federal Circuit to consolidate the appeals, stay the judgment and injunction pending appeals, and grant immediate administrative stay of anything going forward on this. And essentially, the Federal Circuit granted that request for immediate stay. The U.S. Court of International Trade judgments and the permanent injunctions were temporarily stayed until further notice. This would allow the Federal Circuit to consider the motion for the full stay and decide, yeah, we're going to do that. No, we're not doing that. And if they decided no, presumably then they're just going to let the stay go in. At which point then I guarantee you there'd be an appeal to the Supreme Court. Now, we know the Supreme Court's eventually deciding this, let's be honest. Now, the parties are to inform the Federal Circuit of any action by the U.S. Court of International Trade on the related stay motions because it asks them to remove them, modify them, etc. So to the extent the Federal Circuit takes any action, the Federal Circuit wants to know about it, what goes on. And the briefing schedule has been set for early June for both parties to get their information in for the full stay motion, at which point the Federal Circuit can move forward. Now, the implication, this Federal Circuit stay does mean the tariffs are back in effect. It's temporarily for now because we know there is a decision that has to come. So the underlying legal challenges continue and the underlying uncertainty continues that'll be there. Business involved in import activities are affected. You got to advise, if you have clients like that, they need to be advised on the current status of the tariffs. They got to be advised about the future changes that might occur depending on how the appeal works, right? Basically the same thing we have to do for those self-employed, those partners in limited partnerships saying, look, there's an appeal. It could change things. This is how it stands right now. You got to talk about those things. Tell clients, future's uncertain, right? When you have courts involved, we don't know what's going to come. So I have no perfect crystal ball to tell you exactly what the courts will rule. And also, potentially, there may be refunds involved if the U.S. Court of International Trade decisions are ultimately upheld. Now, you want to monitor that Federal Circuit appeal for further developments. decision on the full stay or a decision on the merits, right, in that case. And essentially, what this looks for, though, remember, the court considered specific statutory authority cited for executive actions on trade, the role of Congress in tariff matters. It is a mainly constitutional argument right now as structured. Again, but it does not appear that it appears to me that even if this action is successful, it'll modify and pare back somewhat what the administration can do. But it's not necessarily going to mean that all tariffs will go away entirely. I mean, the Court of International Trade pretty clearly has ruled that, there is probably a justification for, if the administration uses it, the 15% tariff up to 150 days. They can impose those. Now, they would probably argue that doesn't help the negotiating position enough because the other side knows they can just, run out the clock, shall we say, let 150 days go by, game over, and we're done. And the court would probably not look kindly on suddenly finding another emergency the next day and trying to start another 150-day clock. I think they might have a little issue with that. Okay, let's revisit the case of Mr. Welch. Mr. Welch is desperately trying to keep the state of Massachusetts from taxing the capital gain on the sale of stock in the company that he had founded. This case citation is Craig and Natalie Welch versus Commissioner of Revenue in Massachusetts. This is Mr. Welch's petition to the Supreme Court of Massachusetts, and it was published on May the 29th, 2025. We've already talked about the underlying case that was decided at the appeals level. Okay, we already had Court of Appeals level. Now, the key issue was whether a gain from a non-resident founder's sale of stock in a former Massachusetts-based employer is Massachusetts source income as compensation for services. We had discussed when the case came out how the Massachusetts court had decided that, yep, that's how it works, right? Now, this is an issue of first impression, generally in the court, potentially impacts many Massachusetts entrepreneurs and key employees. Because the issue being, if you leave Massachusetts, apparently that stock would continue to carry the taint of being disguised compensation, and therefore the gain would route back to Massachusetts. And while in this case, Mr. Welch had just barely moved to the state of New Hampshire, there's no reason why this theory wouldn't apply to somebody that had been out of state for quite a while. Okay. Now, these appellants are seeking further appellate review because they lost the first appeals course, right, from the Supreme Judicial Court of Massachusetts. Let's get the High Court to rule on it. Now, he was a founder of AcadiaSoft, initially a Massachusetts S Corp, later became a Delaware C Corp. His involvement, he was a co-founder and a 50-50 owner. Initially, he was the CEO, the treasurer, active in sales and marketing. His operational role was reduced later as other parties came in with investments. He received his initial shares in 2005 for contributions he made during formation, what he put in the company. No additional shares or options were ever issued. So the first shares he got were shares that he got from having to put in the initial founding money to start this company up. He did receive significant wage income from 2005 to 2015, and he reported and paid Massachusetts tax on these wages. Now, he is going to say that that's a significant issue. The capital gain is not disguised compensation. Now, around April 30th of 2015, he moved from Massachusetts to New Hampshire. He was effectively if you read between the lines, being squeezed out. On June the 29th, so essentially less than 2 months later, while a New Hampshire resident, he sold the stock back to AcadiaSoft. He reported the gain as a federal long-term capital gain. Now, because as of June the 29th, he was no longer a resident of Massachusetts, he reported this capital gain as not taxable to Massachusetts. It was a sale of stock. And so it's a sale of this intangible asset. Now, the Massachusetts commissioner's position was they assessed tax, arguing the gain was effectively connected to his trade or business as an employee in Massachusetts going back to the founding of AcadiaSoft. Now, the governing statute in Massachusetts is GLC 62, Section 5A, and it taxes non-resident income derived or effectively connected with one, any trade or business, including any employee carried on by the taxpayer in the Commonwealth. Now, there's an effectively connected. This is effectively connected income. Is income that results from or is earned by, is credited to, accumulated for, or otherwise attributable to the taxpayer's trade or business in the Commonwealth, regardless of the year in which that income is actually received by the taxpayer, and regardless of the taxpayer's residence or domicile in the year it is received. It includes gain from the sale of a business or an interest in the business. As you may guess, Massachusetts Revenue is saying it's a gain from an interest in the business that is related to his work there, founding the company and building it up all those years, right? A 2003 amendment clarified the taxability is not dependent on active engagement or residency in the year of receipt. It does not matter that when you finally got this gain from the sale of the business, that you were no longer actively involved in the business. So now we're going to go down to the objections. Now, Administrative Rule 830 CMR 62.5A.13 3C8 subsections there generally excludes gains from the sale of CRS Corporation stock from Massachusetts if it's a federal taxable gain. But there's a qualification. It says such gains may be Massachusetts source income if, for example, the gain is otherwise connected with the conduct of a taxpayer's trade or business, including employment, in a case where the stock is related to the taxpayer's compensation for services. Now, the board's interpretation, what the court said, the board and the appeals court found the definition of derived or effectively connected exceedingly broad. Not impermissibly broad, but a very, very broad definition. They relied upon quantification, allowing taxation if the stock is related to the taxpayers, compensate the qualification is related to his services. And they agreed with the board that Mr. Welch was not a passive investor. It's not like he bought stock in Microsoft, sat there, for 20 years, and then sold the Microsoft stock or the Apple stock or whatever. He was actively and detailed involved, including in building the value in the company, right? Right? He had continued employment and crucial contributions added value to the company. So the work he was doing served to build the value. That's going to be what they're going to base a lot of this on. And they cited fact linking stock ownership and sale to employment. He acquired the stock soon after founding and went on a payroll, expected a payout for his sweat equity, and expressed that in various occasions. The 2009 agreement tied the keyholder status to his employment, and his resignation, leaving the company, was contingent on him selling the stock. If he was no longer employed, he had to sell the stock back, right? Because, they wanted to keep him around as a kind of a board member, and so he was still associated with. He said, I don't want anything more to do with you. As I said, it appears he was being kind of squeezed out. He had to sell back. They said, well, that all indicates it was related to compensation. So based on those facts, the appeals court concluded the gain was derived from his employment. And they said the stated decision was limited to these unique facts. If you were just a salesperson, let's say for Microsoft, or you worked in an Apple store once, that probably doesn't make your sale of your Apple stock when you moved from Massachusetts. Yes, you worked in the Apple store in Boston, and then you leave Massachusetts and 2 years later sell Apple stock you had purchased, while you were in Massachusetts. You sell that while living in Mississippi. No, it's not Massachusetts source income. Now, what is Mr. Welch's arguments for reversal? Well, he said that Massachusetts case law, Dupuy, Oliver, V.A.S. Holdings, confirm a CRS corporation's business is separate from its shareholders' business. A non-resident taxpayer must personally conduct the business giving rise to income. AcadiaSoft's business is not imputed to Mr. Welch. His only business was as an employee. Also said that stock was not attributable to his employment. That stock was received for contributions or formation. It's not stock granted to Mr. Welch, by a company to attract him to come to work for them. It was not for employment services then or later. The stock sold was that original formation stock, and there was no additional grants. Basically, it's just like, many of you listening here may, you've got a CPA firm, you put some money in a checking account to start it, right? You got stock. If it's a corporation, it's like that wasn't, the stock wasn't given to you for being an employee. It was given to you for putting money in, so we could actually open a bank account, so we could pay the electric bills, to get the lights turned on, make the deposits, etc. That's why it was there. And also said Mr. Welch was very adequately and handsomely compensated via wages from 2006 to 2015. That was taxed by Massachusetts. This was not a case of where he took nothing out of the company and just had value building in the company. No, the taxing that entire stock gain, again, as wage income, ignores the fact that he had been more than adequately compensated in those years. And, arguably, probably for federal purposes, in the years it was a C Corp, they might very well have argued for excess compensation being paid to him if they had tried to take that money out as compensation. They also said he's going to say, look, the regulation, if you find the regulation is valid, it supports exclusion because that regulation 830 CMR 62.5A.1 and then subsection 3C8 generally excludes DNS corporation stock if it's federal capital gain. That supports their position, is consistent with case law. Also said there's examples in there at 3C 8.4, describes a non-resident employee purchase stocks and investment with the gain not being Massachusetts source, the Apple Store employee. Okay? They argue their facts are substantially identical because they did purchase the stock. Right? They purchased the stock effectively, right? You put money in a corporation, you get stock, nothing's happened, you bought the stock. And the appeals court erred in dismissing it. Acquiring shares for formation is akin to a straight purchase of the stock. And also said tax laws must be strictly construed with doubts favoring the taxpayer. And the commissioner is bound by the regulation's clear language. And if there's any ambiguity, you have to read that in favor of the taxpayer. Now, what the appellant wants is that this gain should be treated as capital gain from investment, not compensation. And therefore, as such, the state of Massachusetts should not be able to tax it, would not be Massachusetts source. They said the appeals court decision erroneously blurs entity and shareholder distinction that's inconsistent with Massachusetts law and the regulation. Now, the implication, if the appeals court decision stands, it would, as we discussed before, be a significant expansion of what Massachusetts deems effectively connected income for non-residents selling stock, particularly for founders or key employees of a business. If you're going to, let's say, you founded your business, your client founded their business, they can't just pick up just before, if they know they're going to sell the business, they're not going to be able to pick up and, kind of just relocate to a non-tax state, New Hampshire, and then to close the sale, right? That would be it. But as I've said, I also see nothing decision that said, even if, let's say they had the stock, they had been there, right, for years, they found the company they built up just like this did, but instead of having, let's say, selling it to the, getting outside investors and going public eventually, what they decided to do was they kept it in the family. It went to the kids. They then moved to Florida. And then, 5 years later, the kids sell the company for big gain. And of course, dad and mom get, their investment bought back from that and redeemed. Is that going to be considered wage income as well? A little tough to sell. Now, obviously, the court could say, well, no, that we could exclude it at that point because the sale wasn't conditioned on him working there, unlike this one. We'll have to see how they look at it. It is uncertainty for non-residents. And by the way, states are getting, as you might guess, looking for money. States are getting more aggressive because it helps to tax people that no longer vote in your state. That will not get you voted out of office. Bottom line, generally, it won't. Right? So you have to, what it does suggest in Massachusetts, you got to look at the origin of the stock. Was it formation, compensatory grant? The nature of compensation received? Was it truly wages and stocks? And your role in relationship. Did you build value is apparently important here. So you want to keep an eye and see if a Supreme Court decision on whether to grant further review and the outcome if the review would be really important. Finally, we're going to consider the Huang case, which is foreign gift penalties and the first case I can remember for the TurboTax defense. Actually appears like it's going to work. So let's talk about this case. The citation is Huang versus United States of America, case number 24 CV 06298-RS. This is the U.S. District Court for the Northern District of California. May the 29th is when it came down. Now, the question is the application of penalties for late filing of Form 3520, which, as you know, has very nasty penalties if you fail to properly report a foreign gift you have received. We're going to talk about, secondly, the validity of the reasonable cause defense. Is reliance on tax software adequate to sustain your reasonable cause defense in this case? And IRS's authority to assess and collect these penalties. Now, you're going to discover that, the taxpayer here is going to lose two of those three issues. What she doesn't lose, remember, it is 3520, so penalties are the key issue. What she didn't automatically lose, the facts have to be developed at trial, would be whether she properly relied upon tax software in a way that would give her reasonable cause for not having reported and paid tax and not having filed the 3520 in a timely fashion. So this will take a look at how courts view penalties, reasonable cause, and challenges to IRS procedures in this international information reporting cases. I have a few things going on here. Now, Ms. Huang received substantial gifts from non-resident foreign parents in 2015 and 16, right? If you know the rules on 3520, that should have set off alarm bells in you. She needs to file that form to disclose the fact she received that gift. Now, Ms. Huang, though, unfortunately, was not employing a tax professional who, may very well have had a background to understand immediately what the problem was. She rather went and got TurboTax because that's what we do, right? And she claimed that it advised her that only the foreign gift giver needed to report. Now, my guess is she probably misunderstood what was there. That often happens because, these programs tend to report things. And if you don't really understand the question you should be asking, you can often read answers the way you want to read them. But she read it that the gift giver needed to report, not the recipient. Now, honestly, that also is kind of like what you do for 709s, right? The gift giver is the one that has to file and pay any tax. So, could she have been mixing up the app? Very possibly. But again, she's not a tax expert, right? She relied upon that, and she did not file the Form 3520, believing that she'd been advised that it wasn't necessary. Now, she finally learned of her obligation in 2018, in April. That could be because, a friend or somebody, or she actually started deciding these returns are getting too complicated. And she went somewhere and they said, Ms. Huang, we got a problem. We got a big problem, right? And when she did, she filed the 3520s for 2015 and 16. Those were the 2 years she'd received these big gifts, right? Now, the IRS automatically assessed penalties, which they tend to do here. $62,000 for 2015 and $28,000 for 2016. And the manager approved these assessments inside the IRS, okay? Now, she submitted a letter citing ignorance of the law, inexperience, and reliance on TurboTax and asked for a relief of the penalty. The IRS denied, citing a lack of reasonable cause and to show that she had exercised adequate due diligence in determining her filing responsibilities. Now, during the actual appeal, though, magically, somehow, we had what the court referred to as penalty inflation. The penalty amount mysteriously increased from the numbers that we first started with to over $153,000. Okay, that's kind of there, right? Now, on appeals, they abated the inflation portion, $117,000 plus, noting at this point. So they noted the hazard litigation and sustained the remaining $36,000 as being due to a lack of reasonable cause. that she still owed the penalty. It was due to lack of reasonable cause. We do have a hazard of litigation. So even though apparently the appeals may have decided that that higher penalty was a more appropriate one, they decided as the way the case had been handled, there was a high hazard of litigation. So they were going to go ahead and reduce down to $36,000. Now, she paid the sustained penalties, right? And she filed Form 843 for a refund based on reasonable cause. After the IRS made no response to Form 843, right, refund claim after 6 months, she has the right to go to district court. Now, the IRS later issued a partial refund for 2016, acknowledging there was a calculation error had been made. So she's now looking for a refund of assessed penalties, which were about $35,000, and her withheld refunds, because the IRS has been taking refunds in the interim, of $208 plus $759, plus her fees and costs. She had 4 theories under which she was claiming relief. Number 1, she had a reasonable cause for late filing of this form. Number 2, the IRS had acted arbitrarily and capriciously by automatically assessing and inflating the penalties. Number 3, the IRS lacks statutory authority to assess and collect these penalties under Section 6039F. And number 4, the IRS had failed to get proper written supervisory approval. So under Section 6751, even if these penalties were valid, they blew it by not following proper procedure. Now, the IRS moved to dismiss for lack of jurisdiction and a failure to state any viable claims. Let's walk through the 4 claims. First claim, the taxpayer won, well, kind of. By that I mean this was a decision on the government's motion to dismiss based on the fact that this particular claim could never prevail. The court found that Ms. Huang had properly raised reasonable cause in Form 843. She referenced her prior detailed arguments. That gives the court jurisdiction. So you can't say we didn't have jurisdiction, so we're not going to dismiss it due to lack of jurisdiction. And the next question is her argument plausible? And while the court agreed that ignorance of the law alone is not enough, inexperience and the complexity of the law can combine with other factors. And I think there's little doubt that, inexperience and the complexity of this reporting statute, which is a little bit weird, right? And it's be unexpected for somebody that didn't really understand international taxation, that could be enough to give a reasonable cause as to why she wasn't aware she should have sought more detailed guidance. But what about TurboTax? She did rely on TurboTax, and we know that reliance on a tax pro would be one of the things that can get you reasonable cause. Well, the court viewed reliance on TurboTax advice, which allegedly said no filing was needed. Remember, she's not yet proved it said that. We're not yet at the point of offering the proof. When you're at this point, we're just going to assume that the non-moving party, the party that's not trying to get things thrown out, in this case her, we're going to assume that she can prove all of her allegations, what she says she can. So we're going to accept that. So they said, assuming she relied on TurboTax's advice that no filing was necessary, then that is akin to relying on professional advice. They said, look, prior tax court case, Olson had found reliance on tax software could support a reasonable cause defense or, failure to file. So the motion to dismiss is denied for this claim. They have to go to the merits where, of course, Ms. Huang has to show that she did what you need to do. Generally, for reasonable cause, you've got to show that given your experience and knowledge, you acted reasonably to attempt to appropriately determine your filing requirements, what you should be doing, right? And you took actions to do that that makes sense, that you would have known you should have taken to do this. So if you have, if you know about all the complexity of international law, then maybe, you understand, and you know about how messy this all is, maybe it would have been more appropriate that you should have realized you should have gotten legal or tax advisor counsel about whether you needed to file this form. But that's all factual, right? Court's not going to decide any of that at this point. So the good news is she might win on TurboTax. If she can show that TurboTax, told her no filing was needed and she acted reasonably in how she approached that, she could win. You can win with the TurboTax defense, but it doesn't mean she will win with it. That's not to be decided at the state. The other areas didn't work out so well. On her second claim that the IRS acted arbitrarily and capriciously, first they said it's not raised in Form 843, and a refund suit under 7422 is adequate remedy, barring Administrative Procedures Act review for denying reasonable cause. The claim regarding arbitrary inflation was distinct, but the IRS had already rectified the error and issued a partial refund. So in this case, they said the claim is moot. Now, it was dismissed without prejudice, so she could refile this if she can show some reason why it's not really a moot claim anymore. What exactly is she asking for from this IRS action? Because the court does have trouble figuring out why the IRS suddenly bumped that number up the way they did. But again, as it stands right now, it appears, the IRS rectified the error and it's no longer causing a problem. So, the court says you haven't basically given us near enough in your pleading so far to find that even if we accept everything you said, that you'd prevail. Next, the lack of statutory authority. Okay, this one was probably a long shot, but maybe a district court agreed with it. There was a decision of the tax court, the Fari decision, that essentially said that the IRS really could not just assess the regular way, the 6039F penalty. Rather, they effectively had to sue somebody for that, which would be very difficult. And that's, you had to sue them. You couldn't just use standard collections, the assessment and collect tax method. And tax court had ruled that way. However, the court noted that the DC Circuit's reversal of that decision, because the tax court was reversed, the case was, held in, it was a DC resident. The appeal went to DC. And because of that, the court found that, they said, look, they reversed and we like the reversal better than the tax court's decision. It also suggests the 6039F's reasonable cause defense implies that it's an assessable penalty. Otherwise, you wouldn't need that defense, is their argument. Agency waiver, that is, the plaintiff failed to raise this argument with the agency, so she didn't make it as part of her initial claim. And the claim is dismissed due to the failure to raise the issue with the agency, finding the DC Circuit's Fari reasoning persuasive. So that one is just dismissed outright. And what about under 6751B not getting proper supervisory approval? Well, there is a requirement, case law now provides, in interpreting 6751B, there must be written supervisory approval is needed before a penalty is assessed. The timing rules vary depending on which circuit you're in, but we'll ignore that right now. The record shows a manager approved the initial assessments. And approval can be from a higher level official if it's designated. The agency waiver, the plaintiff again never raised this argument at the agency level, and the claim was dismissed due to failure to raise it with the agency and the evidence that the approval existed. So bottom line, she still can play with reasonable cause, right? So while, the motion to dismiss was denied only for reasonable cause, the arbitrary nature claim was dismissed, but not with prejudice. The other two were just flat out dismissed. So basically, if she's going to win this case and get to keep the $34,000 and get her refunds back, it's going to be under reasonable cause under the TurboTax defense. Now, the implication for those in tax practice. This case reinforces the complex laws taxpayer experience and reliance on specific incorrect advice from tax software, not just general ignorance, might support a reasonable cause defense at trial. The taxpayer would need to document their efforts, background, and reliance. And so if you get brought in to assist somebody that's now going to try to argue the TurboTax defense, yeah, we need to document what happened, exactly what happened, And you got to kind of hope they kept copies of stuff, right? Printed things out from the screen so that we know exactly what TurboTax told them and when, and what exactly they asked and when. The administrative process is crucial. All potential arguments for penalty abatement, including statutory authority, procedural challenges like the approvals under 651B, must be raised with the agency during administrative review or refund claim process to preserve litigation rights. In those cases, she failed to raise the issue with the IRS. She brought it up here in the court. Not allowed to first bring it up in the court. You have to make it part of your administrative waiver, refund request. Now, generally, it supports view the IRS has the authority to assess and collect penalties codified within the IRC. These special foreign penalties are not anything unusual, at least in the view of this court. And Form 3520, it highlights a continued focus on compliance with penalties for international information reporting forms. It's nasty. Don't forget the 3520, right? Understand what it's there. If your client gets a gift from offshore 3520s, you have to think about that one. If you don't do a lot with offshore stuff, it's easy to miss that one. You want to be very, very clear about it, okay? And also, that's also a reason why you need to always ask the clients, right? Most organizers do. But again, clients don't fill in organizers all the time. A lot of times they don't. Have you actually got confirmation from your clients that they didn't receive any such gift during last year? Or do you just go, they didn't feel organized, they gave us the 1099s, that's good enough? Probably not good enough, right? And certainly from a liability standpoint, I think your liability carrier would prefer you ask the questions and get them answered. This has been the current federal tax developments for June the 2nd, 2025. Like I said, it's been kind of a review week because we had both Soroban, and Welch in there. So it's a review, a little talk about tariffs because nothing else really happened this week, and a brief discussion about the issue of somebody may have made the TurboTax offense work. So, I mean, that'd be interesting just for that fact. So, hey, had little things happen, but nothing big. You can email me questions, edzollers at currentfederaltaxdevelopments.com. I'll get that word out right. Right. That's also where the website where you're going to find as we post developments during the week. You'll see them go up there first. I do have a much more detailed description, which is also, by the way, in the in the handout that we have that we keep on the Current Federal Tax Developments website for each week's presentation. We'll also much more carefully discuss the DC Circuit's case. It's not that different from the decision that we saw from the Court of International Trade, so I didn't feel like there's any reason in going over it again to discuss what's there. It's there. There's a discussion there. Again, that case, we're really going to be watching going forward, seeing what else happens, but we'll keep our eye there. I also do look in on the Connect sites for a lot of state societies. So I'm looking at Arizona's Connect site, the Connect sites in Idaho, Illinois, New Jersey, Minnesota, and Washington. So if you're a member of any of those societies, you can post on their Connect tax discussion groups, and hopefully I'll see what you post. Otherwise, we're hopefully going to see you back here next week. We talk about more things. I'm going to be at the New Jersey Society of CPAs convention next week, talking on two topics. One about where we stand on the extension of the TCJA, which really nice Congress waited until just before I had to do it or to actually get the bill out. And also discussing basically the Soroban question we just saw today, limited partners as such, what's the impact of that whole thing and how do you deal with it? And assuming if Soroban wins, I would expect to see the control requirement disappear from a lot of state limited partnership statutes. And then it becomes more interesting. So because of that, it may be a little more fun getting everything written up, but I'm hoping they'll still be able to get it up and recorded and done because, I will leave very, 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 very early Tuesday morning, head out there to get to Atlantic City. And I'm going to get back kind of late on Friday night. So it's going to be kind of in between, but I should be able to at least keep up and read some of the developments and get some of the posts and everything put together. So we'll hopefully get it done So otherwise, though, we will go ahead and see you then, assuming everything comes up, which I think it should next week, as we talk about more current federal tax developments.